LawCall is provided in the public interest by Timberlake, League & Brooks, which pays an advertising fee to the station.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night. Believe it or not, just about every area of your life is affected by the law. If you're starting a business, you're dealing with the law. If you're buying a home or buying a car, you're dealing with the law. Contract law. If you got injured somehow in that vehicle, you're going to be dealing with the law. Maybe you've got a problem at your workplace, or maybe there's a problem in your marriage. All of those things may land you at a courthouse or dealing with lawyers. Tonight is your chance to ask any kind of legal question. It's Ask Us Anything night. So call in your question on any legal topic, 256-536-0077. You can be live on the air with us and ask your question. You can also text your question to that same number. You can also email a question any day of the week on any legal topic. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull some out. We've got some of your email questions tonight. You know, if you're traveling and you love Law Call, you can also watch it on Facebook. So the Timberlake, League & Brooks Facebook page streams it, and so does WAAYtv.com Facebook page streams it. William Zervi's here from Timberlake, League & Brooks. Good to have you here.
Glad to be here.
So cold outside. We thought we might start with some things. We're going to start with some video, but we're going to talk about some winter weather kind of things as well.
It is chilly outside.
Very cold.
And, you know, we've had an unseasonably warm winter so far, so I guess we were due for a cold snap.
We're going to pay for it. So maybe we'll talk about some frozen pipes. We'll talk about some driving in wintry conditions. Call in your questions, though, and while we get some of the calls locked in, let's take a look at tonight's You Make the Law Call video. So, you know, sometimes you can have trouble if you tailgating too close to a vehicle, or sometimes something sneaking up behind you. It's going to be okay. Quick thinking about this SUV driver. He got out of the middle of it, but if he hadn't been noticing what's coming up fast behind him, that could have been really bad. Timberlake, League & Brooks does all kinds of car accident cases and personal injury cases. So when you're looking at that, what are you looking at? What are you most worried about? What do you focus on?
Well, the first thing I'm looking for are brake lights, right? And, you know, it's hard to see from this video how visible brake lights are either on the black vehicle or the 18-wheeler in front of it. You know, but there's rules and regulations both for private vehicles and folks using the roadways every single day. There's even more stringent rules and requirements for 18-wheelers with regard to how much space they need to leave between the vehicle in front of them. And then, you know, what sometimes isn't cut on the video is how long was that black car in that lane of travel.
Okay.
Right? You know, had it just moved over?
Okay.
Or had it not. But, you know, this is going to, the fault's going to land on the 18-wheeler that rear-ended the black vehicle.
Okay.
And, you know, the fault is almost always going to lie with the vehicle who does the rear-ending. Now, if someone, you know, pulls immediately into your lane of traffic or something like that, causes a hazard, you know, it's not 100% always the fault of the vehicle that ends up rear-ending the vehicle in front of it. But the vast majority of times, that's going to be the situation. And, you know, luckily, like you said, that vehicle was smart enough to get out of the way. We've represented, unfortunately, folks who've been sandwiched between two 18-wheelers before, and it's
bad, right?
It's bad.
It's really bad.
Yeah.
We've got callers ready with questions. We've got Myrna on the line with a question from Elkmont tonight. Hi, Myrna. Thanks for calling. What's your question tonight?
Yes, I was wondering when a person passes, if the credit cards and loans are just on that person's name and not on the spouse's name, are they responsible for those bills yet?
Good question.
Yeah. So, you know, typically the responsibility of the bills of a deceased individual are going to lay with the estate. And so typically, you know, an estate is opened that allows the property to pass through and the heirs to make a recovery. Okay, but that estate has to remain open for 6 months, during which period creditors can make a claim against the estate for outstanding debts and things of that nature. You know, credit cards can be tricky because even though they're only in the name of the deceased individual, if that individual is married, they can be considered spousal, right?
Yeah.
Marriage debt. So it's not always as, clean as you want it to be. If you were married and, that debt was incurred through the marriage, my understanding is that the spouse can't be held responsible.
Could be. And when you're going through the probate process, you're required to give notice to all the debtors that are out there. So if you know of that one, you're required to send a notice, or your attorney that's handling it, to send notice directly to that company and tell them, so that they've got a heads up and can make that claim. And if you fail to do that and it was a known debt, that could cause a problem down the road too.
That's true. Now, a lot of times medical bills incurred are not the responsibility of the spouse should that person pass away. Now, if they've already been, put through the collection process and a judgment obtained, then, there could potentially be the same type situation where they're making a claim against the estate.
We've got Robert on the line with a question from Albertville. Hi, Robert. Thanks for calling. What's your question tonight?
Yes, it's about a license. Me and my fiance, we're going to get married here before long, and I want to know what the process is now of getting a license.
Yeah, so, it has changed recently, and I'm not 100% up to speed, but I think Alabama has more or less done away with the marriage license.
Yeah, if you fill out the paperwork and you sign with the notary, then that's the official date, and then you turn in that document. But you don't go to the courthouse and have to do it the old-fashioned way. You can actually have the piece of paper and do it outside of there as well.
Yeah.
So, and I think that most of our probate courts have got some of those instructions online, so you may want to pull it up, take a look at it, and check on it. If the date is important to you, of when the official marriage date would be, check out those requirements.
But you can still go down to probate court, but once you sign the paper, you're married.
You're married, so if that wasn't your intention, you're gonna want to hold off.
It's not like it used to be where they'd give you the piece of paper, whoever officiated the wedding signs off on it, and then
you
turns
could back
it back
out
in.
if you really wanted to. No more.
Yep.
We've got some email questions that have come in. So we had this question from Jason. Jason says, my friend was driving and someone hit us. I don't remember anything from the wreck or about 20 minutes afterward. I had scratches and bruises from the seatbelt and the airbag. I went to the dentist for a chipped tooth. The other driver admitted fault, and her insurance has said that they'll pay for the dentist and give me an extra $200 if I would just sign everything. He wanted me to come in and sign right away and get it over with. I haven't gone yet. Is $200 a normal amount, or should I wait for more?
I'm not sure $200 would be a normal amount for a chipped tooth, much less 20 minutes of loss of consciousness.
It sounds like a pretty serious accident.
The reason they want to get you in early a lot of times is because they don't want you to go figure out exactly how hurt you are. And a 20-minute loss of consciousness can be a substantial head injury. It's not necessarily uncommon for someone to be in a car accident and have a brief momentary loss of consciousness, but it's pretty rare that someone, loses consciousness for 20 minutes, and that's sort of a sign that there may be something, more substantial going on than, just a simple concussion.
So could they go meet with a lawyer and talk about it? So personal injury attorneys, would they have to pay in order to go meet with a personal injury attorney?
Absolutely not. We do free consultations. Always happy to talk with folks. We talk with folks on the phone throughout the day, every day. If you have a question, it's always best to run it by a lawyer first. And that way you can just kind of be sure. But, in a situation like that, they're trying to get you in, dangle that carrot, get you to sign a piece of paper. But then when you figure out, hey, I've got post-concussive syndrome, I've had it for the past 7-8 months, you can't go back and reopen up that claim.
Okay. Even if you find out it was worse than you thought it was?
Even if you find out it was worse than you thought it was. And that's one of the reasons, it benefits the insurance company for them to make some sort of offer early on. It's usually low. We'll pay you $2,500 in your medical bills. And, a lot of folks fall into that trap and then give us a call and say, hey, I need to undo this. But unfortunately, unless there was fraud involved, there's really no way to undo that.
We're going to take a quick break. We'll be right back answering more of your questions. It's Ask Us Anything night. Stay with us.
LawCall is provided in the public interest by Timberlake, League and Brooks, which pays an advertising fee to the station.
You're watching Way 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League and Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is Way 31 Law Call.
Welcome back to Law Call tonight. It's Ask Us Anything night where we've got callers waiting. We're also talking a little bit about winter weather while we're at it. I was in DeKalb County. Cloudmont Ski Resort has got snow, so if you want to go to Alabama's ski resort, we took a visiting cousin Ray by to see because it's so cool. It's very cool.
And a day trip.
A day trip. Cold weather, if I forget or don't drip my pipes and I have burst pipes and I'm a homeowner, is my insurance company going to deny my claim because I was boneheaded and I didn't drip faucets? Can they do that?
You know, that one I think they're going to struggle to say, hey, this is your fault.
Okay, good.
Typically, an acute water leak is going to be covered by your homeowner's coverage. Now, where people run into trouble is with the slow drip. And they say, well, this was a slow drip, but it was hidden behind the wall or it was hidden underneath the house. Insurance company is going to say that's routine maintenance issues.
Okay.
And it doesn't fall under, essentially an acute water leak. And so it has to be acute. Now, you're still going to go through a lot of trouble,
Yeah.
a lot of problems. It's not a fun journey to make a property damage homeowner's claim for something like that, relocate for a time or whatever you have to do, so keep those faucets dripping.
And they may raise your premium too. You have no control over that, right?
Yeah, that's
Even
right.
if they pay it.
And you're going to have a substantial deductible, typically
Right.
2.5% the value of your home, and depending on the value of your home, that can be a lot of money.
We've got Rick on the line with a question from Killen. Hi, Rick. Thanks for waiting. What's your question tonight?
My question is, I went to a company and they said they were going to supply a service and their service failed and I paid for it. And now to get any kind of return on it, I got to go to arbitration.
Okay.
And I need to know what I need to do to go to arbitration.
Now, don't tell us what the company is, but what kind of service was it?
Well, I can't really tell you that.
Okay, that would give it away. Okay.
So, it's a struggle to get any sort of service these days without having to sign an arbitration agreement. But arbitration is essentially signing away your right to go to court. Now, you're still going to have very much a court-like proceeding, but that court is not going to have a jury. It's not going to have a judge. It may have a retired judge. But typically, it's just going to have a lawyer who's been trained in arbitration. And he's going to serve both as judge and jury in your arbitration proceeding. Now, typically, you still have to follow Alabama rules of civil procedure and Alabama rules of evidence. And, so it can be a tricky process to navigate. There are a lot of rules associated with it, and the arbitrator should go over those with you. But essentially, you're going to go and you're going to put on a court case in front of this neutral party that's been agreed to by both the plaintiff and the defendant in this particular matter. And that particular individual is going to be, the judge and the jury, and he's going to basically make a determination. That determination, generally speaking, is not appealable.
Oh,
so you can't say, well, I don't like what the arbitrator decided, so I'm going to appeal to the circuit court. No, you're not. That was, signed away, unfortunately, in the process. So it can be a struggle.
And arbitration is different from mediation. Arbitration is an actual decision. Mediation, don't get those two confused. Mediation, because we do mediations sometimes with family law where you've got someone that tries to help you come to a settlement, but they're not official. They don't get to make the decision. So very different if you are ever faced with those two things. We've got Margie on the line with a question from Huntsville. Hi, Margie. Thanks for calling. What's your question tonight? Hey, Margie, are you still with us?
Yes.
Hey, Margie. Thanks for waiting. What's your question tonight?
My question is, I'd like to know, well, first of all, let me start like this. My daughter had some painters to paint my house.
Okay.
And they messed some of my furniture up, and my mattress on my bed and my table. They took you know how you got the middle part of your table?
Mm-hmm.
They took that loose from under there. They did a little everything, but now they come back. During the day, I be here, and at night, they be spraying something. And the reason why I said it was poison, because I had stainless steamer to come out and clean my mattress, and he said, this is poison.
And you think it's just the paint chemicals, or you think it was some kind of paint cleaner, paint additive or something? Or do you know? I think we've lost her. Painter. A painter comes in and sprays, and you feel like they've left behind some kind of chemical that's harmful to you. I haven't heard that before, but if you had a situation like that, I guess you could bring a lawsuit. Whether you could win, I don't know. Would be tough.
You know, if someone was hypersensitive to chemicals, they're going to have a hard time making a recovery in a process like that if the chemicals used were, you know, routine chemicals that have been, you know, deemed safe for household usage. Now, sometimes those develop on down the road. We find out, hey, this chemical wasn't safe, and it turns into a class action, which is a little bit different. You know, but in a scenario like that, there are some tests that you can run. There's some air quality tests and some different things to see, you know, if there's something strange being put off. But absent something, you know, being put in your house that wasn't made to be put in your house, you're gonna have a tough time making a recovery in that type of case.
And if you had a case like that, a lot of times people will come to lawyers and they think lawyers might take on the case. There's a lot of expenses to proving something like that, right? And she's probably going to be looking at having to foot those expenses in order to get a lawyer to take.
That's the tricky thing, you know. A lot of times you can start with, they sell these air quality tests in Home Depot. Or we get this question a lot with mold, right? And they have this very similar test. You can go to Home Depot, you buy the kit. It's like $4 or $5. Oh wow! And then you know, put in the sample and you send it off. Now to run the results is more expensive. It's you know, $100, $200, whatever it is. Those tests in and of themselves aren't going to hold up in court. So, but it's a good starting point to see, hey, do I have mold, or, you know, is this some strange chemical that's been put in my home? You know, you can run that kind of simple test, and then if that comes back positive, you can talk to a lawyer, you know. But you're exactly right. If a lawyer is going to bring a case in that type of scenario, they're going to have to hire an expert to run the testing.
Which might cost what? That's not cheap, right?
That could be in the $5,000 to $15,000 range. You know, so that kind of leads to question number 2, which are, what are the damages? Well, I had coughing, I had sneezing, you know, lasted for a week or 2 and felt normal after that. Or I had a sore throat for a little bit, you know, but after a couple of weeks I was feeling better. Well, in a scenario like that, you know, even if you were to win that case, you might spend more than you ever got back out of it. So you're going to have, you know, some damages as a result of it, you know, some sort of lung condition developed, or some sort of, you know, toxic blood syndrome, which we've seen before. So, you know, you can have the stars align, so to speak, and have a case like that. But generally speaking, it's rare, because either the time period goes away and the person's feeling back to normal, and then it's sort of the old adage that almost only counts in horseshoes and hand grenades, or it's a scenario where, you know, you're unable to really put your finger on what it is that caused the underlying symptomology. Because ultimately, you're also going to have a physician willing to say, hey, yes, this person has this condition, and not only that, they didn't develop that condition naturally or from some random source. That's a condition that, you know, generally speaking, is caused by this chemical or this type of mold. and then you've got to have the testing showing that you had that type of mold or something else.
Okay.
So it's, you know, they're hard cases.
We
They
got
really
this
are.
text question in. Someone who is from Falkville got arrested for a warrant that he didn't know existed. This was in October last year. Some kind of retail theft, and all that he's been told is that it's a third-degree criminal charge. He's not aware of the place where it happened. He's trying to figure out what to do with this. Does he just need to hire a criminal defense lawyer? He just feels like he's being falsely accused. Thoughts on that?
He may need to, you know, or, you know, if you have a warrant, you're typically going to turn yourself in,
Okay.
bail out, and then, you know, you either have an attorney appointed to you or you can contact an attorney. But, you know, in a situation like that, it's typically rare that someone doesn't know they had a warrant out for their arrest. You know, typically they miss a court date,
Yeah.
or they don't show up for something, you know. But in a scenario like that, it is possible, you know, that the store took video footage down to the police station after the fact and, you know, they swore out a warrant. But typically they're going to try to, you know, put you on notice of that. You know, you can turn yourself in and then you can, you know, address your grievances in court, which is what it's there for.
A criminal defense attorney may also recommend when you're going to turn yourself in and to have a bonding company or somebody lined up. You don't want to do it on Friday evening that you're going to get stuck somewhere. So go visit
very good advice.
Criminal defense attorney and plan it to be sure you're not going to be locked up for a long period of time. We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night.
LawCall is provided in the public interest by Timberlake, League and Brooks, which pays an advertising fee to the station.
With William Meservey, Timberlake, League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And for Sharon Doviet, who practices family law, all things divorce, child custody, here in Huntsville, 256-539-7337. You can find her online at www.sharonfamilylaw.com.
Cold weather, if we get snowy stuff, closed roads, you got any advice on that?
You know, stay off of them. Even in what you would think is a wreck that is not your fault, you may not be able to recover if you've driven onto a road that has been closed down by the authorities.
Okay.
So if the roads are closed, stay at home, do your grocery shopping beforehand.
And maybe it won't happen. Maybe we'll have a nice clear week, just very, very cold. Thanks for all your calls and questions, and we'll see you next week.
Good night.